Court calls the case People versus Tage Seth.
Nicole Hughes on behalf of the people.
And good afternoon, Your Honor. For the record, Orlando Simone, Student Legal Services, on behalf and with Mr. Sheth, who's appearing via Zoom. Tage, would you please unmute and state your name for the court?
Tage Sheth.
Thank you. And Your Honor, we're before the court today, and we're ready to proceed with a resolution. We've provided the court with an advice of rights form that I've gone over with my client, who's signed and dated that. Ms. Hughes and I have a resolution on both cases. As to the 5076 case, we provided the court with a plea form. My client would be pleading to the added count 2 of attempted R&O, the understanding that the count 1 will be dismissed. In the 5637 case, my client will be pleading to counts 3, 4, 5, and 6 with a request under sentencing under the Homes Youthful Trainee Act. With the understanding
He'll be pleading guilty to counts 3, 4, 5, and 6.
Correct, Your Honor. And requesting sentencing under the Homes Youthful Trainee Act, and counts 1 and 2 would be dismissed in that matter. Ms. Hughes, is that correct?
He's pleading to a total of 5 different counts, correct?
That is correct.
That is correct. And to be clear for the record, he is not approved for HIDA in 5076, the attempt R&O. In 5637, the 4-count misdemeanor on the complaint, I have entered into a sentencing agreement where the defendant is approved for HIDA in that file only.
And that is correct statement, Your Honor. It's our understanding.
Okay. Understanding I can't bind the sentencing judge in this matter, but I understand what the parties are attempting to do. There shouldn't be a problem. But
and Mr. Sheth understands that as well, Your Honor.
All right. Sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
On the date of April 21st, 2023, at the location of we've come into contact with Ann Arbor police officer.
I ran.
Your Honor, if I may.
Okay. Pardon?
Your Honor, if I may ask questions.
Go ahead.
Thank you. Mr. Sheth, on April 21st, were you in the area of the Greenwood block?
Yes, I was there.
And at that time, police had come to the Greenwood there to shut down a large block party?
Yes.
And then there was an altercation, and police started coming towards you at one point, and did you run from them?
Yes.
And you saw that there were at least 2 uniformed officers acting in their duty?
Yes.
And you continued to run from them down an alley and eluded them from the scene, correct?
Not really down an alley, but yes, I eluded.
Is the court satisfied?
Well, you knew that you were supposed to stop for these police officers. Is that correct?
They did not command me to do so, but yes, I believe I could have stopped.
Mr. Sheth, were you running from the police and they were directing their efforts to come to you as part of an altercation?
Yes.
And did you believe that you were required to stop and you ran anyway?
Yes, they tried to pull the cartridge taser on me. That was when I knew they wanted me to stop.
And you continued to run even when they did that?
Yes.
The young defendant walks in confident, thinking the plea deal will save him smirking face. He smirks, talks back to the lawyers, and rolls his eyes during the hearing. Judge Simpson reads the deal aloud and pauses, clearly not impressed eyes. The courtroom tension rises. Everyone can feel something is about to happen. First moment of panic flashes across the punk's face as reality starts to sink in balance scale fire.
Is the court satisfied, Your Honor?
Well, that seems to be enough. If he'd answer his question straight, then we could get this done. On March 16, 2023, at the location, what did you do at the Michigan tech shop that makes you think that you're guilty of the retail fraud?
I left the store with a pair of headphones without paying for them.
All right. The store was open to the public at the time?
Yes, Your Honor.
You didn't have anybody's permission to take that property, did you?
No, Your Honor.
And this property you took was property that was offered for sale?
This was for sale, yes.
Did you only take one item?
Yes.
Hey, folks, somebody explain to me the distinction between 3 and 4 then.
Your Honor, if I may. Mr. Sheth, as to count 3, that was on or about March 6th, close to 3 o'clock in the afternoon when you entered the U of M tech store, correct?
Yes.
And you took one item without paying for it, as you indicated, yes?
Yes.
And you believe the value of that item to be at least $200 and less than $1,000?
The tech shop was selling it for $349, but you could buy the same item at Walmart for $169.
Well, geez, oh, Pete almighty.
Mr. Sheth,
Okay, look, I'm not going to play his game with this. That was a very direct question. We had very direct questions on the other one. It seems to me that he wants to skirt what he's done. So
I will not
will
waste
be
your time.
more than happy. Sir, do not interrupt me. Ever. So I will take his plea when he decides that he wants to be straight about what he's done. So I'll pass the matter. Mr. Simone, if you want to get on the phone with him and have him understand how he's supposed to answer your questions and or the court's questions regarding this plea, we'll finish it today. Otherwise, we can do it another day, or otherwise, I will just set it for an exam. Those are going to be the options. Court is passing these matters. Court recalls the case of the people versus Tej Seth.
Nicole Hughes on behalf of the people.
and Orlando Simone Student Legal Services, Your Honor, in behalf of Mr. Sheth. Mr. Sheth, would you please unmute and state your name again for the court?
Page Chef.
Thank you. Your Honor, apologies for the needing to pass this matter. We are ready to proceed with taking the plea.
Is he going to answer straightforward the questions? Because otherwise, I'm just not going ahead. I mean, I let it pass 3 or 4 times with him. If he can either answer the questions or not.
Your Honor, we are ready to proceed. If I may, if I could expedite this matter, Your Honor, if the court would permit me to ask questions on each of the.
You can go right ahead because he wasn't answering yours any better than he was answering mine. So go ahead, counsel.
Thank you, Your Honor. Is the court satisfied as to the count 3 that we left?
No,
Okay.
because he said he took the headphones. Then when we got to the issue of value, he started saying stuff.
Okay.
So
we'll begin with count 3 then, Your Honor. Mr. Sheth, as to count 3 on the case number 5637 on March 6th, were you in the University of Michigan tech shop around close to 3 p.m., 2:50 to 3 p.m. on that afternoon?
March 6th or 16th?
16th. And if we could change this to a date range on the complaint, that is going to fix part of the problem here. We should have charged this as March 16th to April 25th. And then he'll talk about how he keeps going back to the store and stealing all this stuff.
Okay. You have any objection to that amendment?
That's fine, Your Honor. We have no objection.
And so that's from March 16th, 2023 through what date? I'm sorry, Ms. Hughes.
I believe April 7th.
No, April 25th, 2023. Thank you very much, Your Honor, for making that amendment.
Okay, go ahead,
Mr. Chef, as to all three counts of retail fraud, were you in one of the University of Michigan tech stores somewhere between the dates of March 16th, 2023 and April 25th, 2023?
Yes, that is correct.
And on three of those occasions, starting with count 3, that was one occasion you were in the U of M tech store, correct?
Yeah.
The judge interrupts the discussion. Gavel hits hard hammer collision. This deal is unacceptable. You've shown zero remorse. The young punk tries to speak, but Judge Simpson immediately cuts him off. The courtroom goes silent. Lawyers whisper. The defendant's confidence crumbles before everyone's eyes flush face high voltage. This is the moment he realizes he's not walking out easy.
And on that occasion, did you take, without paying for it, a pair of headphones?
Yes, I did do that.
And you understand, it's your belief that the value of that was at least $200 and less than $1,000, correct?
Yes.
And you didn't have permission to take that item, did you?
I did not have permission.
And the U of M tech store was open to the public?
Yes.
Your Honor, is the court satisfied as to count 3?
Count 3, I'm satisfied.
As to count 4, Mr. Sheth, on this occasion, sometime between those dates, which you've already stated on the record, did you enter one of the U of M tech stores and again take a pair of headphones, a different pair of headphones?
Yes.
And you believe the value of that particular set of headphones was at least $200 and less than $1,000?
Yes.
And did you have permission to take that item?
I did not have permission.
And you didn't pay for it?
I did not pay for it.
And that store was open to the public at the time?
Yes.
Is the court satisfied as to count 4?
Think you've made a factual basis. Go ahead.
As to count 5, Mr. Sheth, this was a third occasion where you entered one of the U of M tech stores, correct?
Yes.
And you took an item that was for sale, that was, what item did you take on that occasion? It was
A JBL Bluetooth speaker.
Speaker. And it's your belief that item was less than $200 in value, correct?
Yes.
And you didn't have permission to take that item?
I did not.
And the store was open to the public at the time?
Yes, it was.
And you didn't pay for the item?
I did not pay for it.
Very well. And as to count 6, somewhere between March 24th and March 27th, and did you have permission to enter from the owner?
No, not from the University of Michigan.
Is the court satisfied as to count 6?
As to the factual basis, I'm satisfied. Counsel, has the court complied with the court rule, and would it be proper to accept this defendant's pleas to these 5 charges?
Yes, Your Honor.
We are satisfied, Your Honor. Thank you.
Court will accept the defendant's plea of guilty to count in case ending in 5076. His plea of guilty to count 2, count 1 is dismissed. A pre-sentence investigation and report is ordered at 15th District Court. Sentencing in that case will be
November 16th at 1:30 p.m. with Judge Valvo.
November 16th, 2023, 1:30.
Yes, sir.
Before Judge Valvo. In that matter, bond will continue. In the other matter, court will accept the defendant's pleas of guilty to counts 3, 4, 5, 6. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered in that case. Sentencing
November 21st at 8:30 a.m. with Judge Perry.
November 21st, 2023. What time?
8:30.
8:30 before Judge Perry. Bond in this case will also continue. Court does call the case, People versus Deanna Wells.
Marie Recency on behalf of the people.
Deanna Wells. Good morning, Your Honor. Good afternoon, Your Honor. Tiffany Hughes on behalf of Ms. Wells.
Deanna
All
Wells.
right.
Can you hear me, Your Honor?
Yes, I can hear you.
Okay.
All right, what are we doing on this matter?
Your Honor, I was just made aware of yesterday that there's a video that I need to pick up from the office, so I'd ask for a brief adjournment to get that discovery and go over it with my client.
Okay. So you're seeking an adjournment.
Yes.
We have a bigger problem, and that there is a bond violation report. Do you have a copy of that bond violation report?
I do not, Your Honor.
Okay, so it's gonna be one of those days. The bond violation report reports that on October 5th, 2023, she's on a scram tether device. On October 5th, there was a drinking event, 0.073, and it decreased slowly. And that event was confirmed by JSG as a drinking event. That's on
Ms. Wells, let
on
me finish talking.
Sorry.
On October 6th, Scram Bracelet detected another drinking event at approximately 11:27 p.m. That was a 0.043, and then it slowly decreased. This was also confirmed as a drinking event. October 9th, 6:20 p.m. Alcohol was detected by the Scram Bracelet. The event showed a reading of 0.028 at approximately, and it slowly decreased until there was a reading of 0. It was confirmed by JSG and the manufacturer as a drinking event. On October 14th, 7:12 p.m., the alcohol was detected by the Scram Bracelet. This event reached a peak of 0.064 and slowly decreased until it was 0. That event was confirmed by Judicial Services Group and the manufacturer as a drinking event. Defendant stated that where they live was...
Judge Simpson explains the consequences. Harsher sentencing, no shortcuts, and the full legal weight of his actions. The punk sits frozen, hands shaking, mumbling excuses that no one is listening to. You gamble with the system and lost. The judge warns. The entire courtroom watches as instant regret overtakes the young defendant, fearful face fire. No plea deal, no mercy, just reality, pure justice served.